Hi everyone, and welcome to today's webcast, talking about the big issue of casual employment. My name's Kyle Scott, and today I'm joined by my colleague Claudia Simmons. And so we're going to spend the next hour taking you through this issue. I think it's quite timely given reform commencement dates, but
26 August.
26 August. So we've got a few weeks for businesses out there to get organised in terms of understanding what the changes are. Obviously, lots of employers out there have casual employees on the books. Some have more than others. So if you're a business that have a decent number of casual employees, it's obviously a really critical issue to get your heads around and start to understand what you need to do and what the changes are come 26 August. I mean, at the outset, I think just to contextualise it, we've had 2 years of progressive reforms, kind of progressively coming in. Pretty significant reforms, if you think about...
Quite a lot.
Yeah, changes to enterprise bargaining, fixed term contract restrictions, pay secrecy.
Positive duty.
Respect at work, kind of sexual harassment based reforms, criminalisation of wage theft,
so much.
The list kind of goes on and on. The right to disconnect, lots of stuff happening in the world of employment law. So I think for HR practitioners or business owners out there, it can get overwhelming in terms of the amount of change. There's because the changes are progressively being introduced, it's challenging to kind of stay on top of when things are, whether something has come in.
When the commencement date
is. What it means.
What the transitional provisions are.
Absolutely. The transitional arrangements for a lot of this can be very complex as well. So, if you're feeling overwhelmed, I can understand why you might feel overwhelmed. I think, hopefully after today's webcast, we can move from a state of overwhelm to a state of a little bit more confidence to understand what we need to do. So if we can move you from that mindset to the next mindset, then hopefully we've done a good job. So on that note, I suspect we should jump into it.
So the agenda. First, today we're going to start by taking you through the evolution of casual employment. We're going to talk about defining casual employment and how this notion has developed over time. We're then going to take you through the new definition of a casual employee and what this means under the new reforms. And when determining whether a worker is a permanent employee or a casual employee, what are the types of factors that we need to weigh up and consider? We're then going to talk about the new employee choice pathway and how this differs to what is in place currently. So the casual conversion process and what this new process is going to look like going forward. Following this, we're then going to discuss the new obligations in relation to the casual employment information statement.
And it's a bit of a it's
a mouthful.
It's wordy, yeah. It's like we've got have we got now a Fair Work information statement? I believe there's a fixed term employment information statement. There's a casual employment information statement.
That's right.
Who knows what might be next, but there's lots of information statements, and we'll talk about this one
later on. We've also got protections in place for casual employees, so we'll come to that a bit later in the presentation. And then finally, we want to be able to provide employers with some practical tips and some action items, I suppose, as we approach the commencement date of 26 August.
Yeah, and I suspect some of those practical tips will be embedded throughout the hour session, but we will have some at the end as well.
Yeah, so that's a snapshot overview of what we're planning to cover in today's session. So I might...
Yeah, well, you've humoured me because I was very keen to just, at the outset, have a quick discussion, hopefully a quick discussion about the evolution of casual employment, because I think it's interesting, it's fascinating, but it also helps to set the scene in terms of what the law was, what the law will be going forward. So thank you for letting me have a bit of a history run. So we might move to that slide. So if we think about casual employment, and there was a fairly significant decision, I think about 2016, 2017, from the full bench of the Fair Work Commission, where they effectively reviewed, in the context of reviewing all of the modern awards, they were asked to consider changes to minimum engagements and the introduction of casual conversion rights for casuals and minimum engagements for part-timers as well. So in the context of that fairly significant proceeding, the full bench looked at, I kind of did this first principles look at casual employment, the history of casual employment, the meaning of casual employment, et cetera, et cetera. And so there's a section of that decision that kind of steps through the history, which I thought was quite interesting. And so if we go back to the early 1900s, there's this notion of daily hire workers. And I suspect that there's still some modern awards out there that might use the phrase daily hire. They might use the phrase weekly hire, or at least I think there's probably some awards that still have that language. If not, well, as recently as a few years ago, they would have. And so they're slightly kind of unusual phrases for people who have grown up and lived in the Fair Work era, because those phrases they're not in the Fair Work Act. If we think about the Fair Work Act and modern awards, we think about, well, full-time, part-time, casual. You might have fixed-term employees. There's then obviously independent contractors. And so the question is, well, where do these phrases come from? So from what I can tell, if you track it back to the early 1900s, there was this notion that, and particularly it seemed to be on the waterfront at docks and places like that, where some people would have permanent jobs. And so they were weekly hire employees who could walk through the gates and they had permanent work. Then at various times, presumably in times of, economic hardship, there would be a bunch of men, and they were men back in those days, bunch of men standing outside the gates hoping to get a day's work. And the foreperson or the manager would call out and say, we need 20 people. And they'd open the gate and they'd let the first 20 through. And so those people were considered daily hires. They were hired for a day, they got paid for the day, and that was it. They had no guarantee, and then the next day, presumably, they're back in the crowd trying to jostle through to try and get through the gate to get another day's work. And between early 1900s up to about the 1940s, 1950s, there was this, in some of those early awards, there was this notion and distinction between daily hires and weekly hires. And weekly hire is effectively a synonym for full-time permanent employees. But in that context, some of those early decisions as well in the 30s, and we've got a quote there, they were considering it in the context of workers' compensation. They considered this notion of, and it was usually about if someone gets injured, they've got workers' compensation available to them. How do we calculate what payment they get when they're on workers' compensation? And so that's obviously difficult if someone only works one day a month. But there was this quote, which I'll paraphrase or I'll read out.
Slide.
But they were considering what does it mean to be a casual employee for the purpose of calculating workers' comp things. And this was Justice Dixon at the High Court, 1937, where His Honour said the expression casual is a word of indefinite meaning, which elsewhere has caused difficulty. And so His Honour called out the fact that there's elements of chance or discontinuity, so a lack of security, occasional intermittent, etc., etc. But they've said that it's been found so difficult to fix any definite test for casual employment because of each case is going to turn on its own facts. I like the point that it's not the Workers' Compensation Act there, it's the Workmen's Compensation Act. So it shows how society changes in less than 100 years. But if you think about that, what Justice Dixon in 1937 was grappling with around what is casual is the same discussion.
It's still what we're talking about.
90 or 85 years later, we're still having the same discussion, and I don't know that we're any closer to really knowing what it's all about. So I thought that was interesting. If we move to the next slide. So I've talked about the 1930s, 1940s. I think 1941 there was a big case involving the manufacturing award and looking at setting terms for permanents but also casuals. And that award defined a casual as someone who was engaged and paid as such. Now, it's a really interesting phrase. It's one that just by kind of historical development continued and persisted and found its way into modern awards. And so most of the modern awards that were made from 2010 onwards, a lot of them did define a casual as someone who was engaged and paid as such. And that definition has only very recently been removed. And if you think about, well, what does that mean? In short, it's if I engage you as a casual, so I call you a casual, and I pay you as a casual, then you are a casual. So there was no, within that definition, there's no kind of contemplation of what hours are you
Conduct.
working, how regular the hours are. It's just if we call you a casual and pay
That's
you a
what you
casual
are.
loading, then you're a casual. So that's been in awards since 1941, from what I could tell. So quite interesting. But at the same time, in a slightly different context, courts were grappling with what is a casual. And I think, prior to the Fair Work Act, in the Workplace Relations Act, there were unfair dismissal protections. And so some of this came about in the context of trying to work out whether an employee who wanted to bring an unfair dismissal claim was exempt. And so if you're a casual, you're exempt. And so they looked at that. And they effectively adopted this different formulation. So the essence of casualness is the absence of a firm advance commitment as to the duration of the employee's employment or the days or the hours that they work. And so I think that quote comes from about a 2001 decision of Tricon. And so that became quite an important authority as well. And so if you just pause there, they're two very different definitions of casual that we have running kind of in parallel throughout the late 90s, early 2000s, all the way up until the Workpack and Scheme case, which was a kind of which was the catalyst, I think, for a lot of the change that's happened since. So just to summarise that, we've got awards with a particular definition. We've got court decisions looking at who is a casual in a slightly different context, developing a different definition. We then had the Fair Work Act that came in from 2009 that had no definition at all of who a casual is. And so hence this uncertainty. And so then we get to the 2018 decision, Workpack and Scheme. And so we'll unpack that because I think that, again, sets the context for these changes.
Oh, the graph.
I forgot about the graph. So I wanted
a graph.
I already thanked you for humouring me. That was my kind of historical dissertation of the evolution of casual employment. Before we move to Scheme and Workpack, though, what I wanted to do is just what we've had over the last 10, 15 years is a little bit of a narrative around insecure work, casualisation of the workforce, and, for example, from the union movement, focusing on all of the negative aspects of insecure work. There's two perspectives, and it's interesting because, on one view, they're both correct, but they're talking about slightly different things. So what the employer groups have said, and this came out through that fairly major case in 2016, 2017 that I referred to earlier. On the one hand, the unions will adduce expert evidence that would say, there's been this significant increase in casualisation and insecure work. And on the other side, the employer groups would say, well, hang on, if you look at the rates of casual employment, the rate of casualisation did jump up in the 80s, and that was kind of part of this globalisation transition to a service economy. But then from about the 80s, it's basically flatlined. And so this is the best graph we could find, which looks at 1992 to 2021. So it doesn't quite show over a longer period, but it's effectively, if my maths is right, a 30-year graph. And we've got casual employment sitting anywhere from 21.5, going up to about 25%, but then coming back down to about 22. So if you look at that at a high level, you'd say, well, the rate of casuals hasn't really changed at all since the early 90s. Now, you have to be a little bit careful with statistics because you've got to look at, what this defines as a casual. And I think the best data is the ABS data, but it's effectively census data or whatever it is. It's looking at, do you get paid a casual loading, yes or no? I think that's the source of the statistics. So that's that on the one hand. And then with the union movement would say in response to that, well, it might be true that the rate of casuals, the technical interpretation or definition of casuals has flatlined. We accept that might not have gone up, but we're talking about something slightly different. We're talking about insecure work. And so the union movement would say, well, that's not just casuals.
And when we talk about insecure work, we're not, as you say, we're not just talking about casuals, they're fixed term employees, might be part-time employees who are looking for more hours, independent contractors.
And I think that's right. So the distinction, the conflict between those two versions are really just that they're talking about slightly different things. if the union movement would talk about insecure work as being a broader banner of which it's not confined to casuals. You take gig economy workers, for example, they would include that cohort of the workforce. As you say, part-timers who might be underemployed, so they might want more hours, and others. So it's an interesting debate and narrative, but I think it's helpful to talk about as well because that's been the context for which casual conversion has come in and other things. So, all right, we are...
Moving on to the key decisions.
Yeah, so we'll talk about Skene and Workpac.
Yeah, so firstly, Skene and Workpac. This was a full federal court decision. Involved Mr. Skene, who was a fly-in, fly-out mine worker. He was paid relatively well, and because of the nature of the fly-in, fly-out type of work, Mr. Skene's roster was set well in advance, 12 months in advance.
Yep.
So he had a very good idea about when he was required to work. Mr. Skene brought a claim under the NES because he believed he was a permanent employee and therefore he was entitled to leave. This decision was significant because Mr. Skene was found not to be a casual employee, and this decision highlighted that simply offering employment on a casual basis and paying someone a casual loading will not be enough for the working arrangement unless you have the characteristics of casual employment.
Yeah.
And here there was a clear pattern of work. And then we moved to Workpac and Rosado. This was...
Before we move to Workpac and Rosado, because conceptually, what was really interesting about Skene and Workpac was you had, as you say, casual effectively claiming to be a permanent and wanting access to unpaid leave entitlements. As you say, a casual who was working very regularly with a roster 12 months in advance. But when the courts were considering, is he a casual, is he a permanent, and he had an employment contract that said he was a casual. What the courts found was, and they applied those two different definitions that I talked about. So I think for the purposes of the enterprise agreement, it had the definition engaged and paid as such. So what, from memory at least, what the court said was, for the purposes of the enterprise agreement, he may well have been or he was a casual. So he was a casual under the EA. But then they turned to, okay, well, what about the NES, which sits in the Fair Work Act? That's where there's 4 weeks of annual leave and other things. Was he a casual, even though he was a casual for the purposes of the enterprise agreement, was he a casual for the purposes of the Fair Work Act and the NES? And as I said before, the Fair Work Act had no definition of casual. And so despite the EA defining a casual as engaged and paid as such, and him meeting that definition because he was engaged and paid as a casual, they said, well, no, hang on. For the purpose of the NES, we actually apply that other definition, which is, firm advance commitment that we talked about in that other stream of case law. And so you had this bizarre scenario where the court said, for the purposes of your entitlements under the EA, you're a casual under the EA and you're entitled to blah. But under the NES, you're not a casual, you're a permanent. And it was like, how could this possibly, how could that possibly be right? But that's what the court said. And so, it just kind of created pretty significant dramas. So I'll let you talk about Rosado.
That's all right. And then we move on to Workpac and Rosado, and this was basically a continuation of the Skene litigation. The High Court considered, again, what is a casual and what needs to be considered when weighing that up. In this decision, the High Court held that the focus must be on the terms of the contract rather than the reality of the arrangement and what was occurring in practice. And that is, the basis of the offer of employment and the acceptance of that offer, not the subsequent conduct of the parties.
So, and I think that was about 2020, maybe 2021. I can't quite remember. In a COVID and post-COVID world, everything's kind of blurred. But the High Court's decision in Rosado was a very kind of technical, legalistic, I think probably, on my view, correct, but it was quite a technical application of contract law principles. And so what they said was, well, hang on, almost before you get to the enterprise agreement or the national employment standards or any of that statute, you have to start by saying, well, hang on, the terms of employment are governed by an employment contract. If we apply, if there is a dispute as to what the terms of the contract are, then you obviously apply contract law principles to say, well, how do we interpret the contract? And the kind of major critical kind of influencing factor there was the question as to whether you could consider post-contractual conduct in order to interpret the contract and find whether the person's a permanent or a casual. And so what the High Court said was, no, on contract law principles, if all of the terms of employment are properly set out in a comprehensive document, so there's no partly written, partly verbal terms of employment. If you have a written contract that sets out all of the terms, then you apply the test as to whether someone's a permanent or a casual by reference to those terms. You don't actually go and look at the subsequent conduct. Whereas the full federal court were looking at the reality of the arrangement.
Yeah.
So quite technical. And the practical upshot of that is the High Court, obviously the highest court of the land, is effectively clarifying this issue and saying the test is dependent on the contract. So for employers and for employment lawyers out there, that was somewhat reassuring, because basically,
if you've got a contract,
if you have a contract
says they're a casual,
and the contract is complete and it's well drafted, then there should be no ambiguity. You've got certainty. So I think the High Court decision gave us certainty, but we then have had obviously legislative reforms following the High Court, and effectively those reforms are intended to circumvent or go around the High Court decision and go back to that full federal court position. So that brings us, I think, to the current reforms that we're debating, the reforms that are coming in on the 26th of August. So this slide gives you what is, as of today, the current legal position. And then we have the next slide talks about the new definition that comes in effective 26 August. But as of today, what is the definition of casual employment? And sorry, I missed a step there. Following that Rosado High Court decision, what the government did was they said, okay, well, all of this controversy has occurred because there's been an absence of a clear statutory definition of who is a casual.
Yes.
Let's adopt Rosado. Let's put in a clear statutory definition into the Act that effectively reflects the position as set out by the High Court. So I think in 2021 or thereabouts, Section 15A was put into the Fair Work Act, which effectively, as I said, reflected the Rosado position, which is the definition of casual is absence of firm advance commitment of work. But they say you apply that test by reference to the terms of the employment contract, i.e. you don't look at the subsequent conduct. So Section 15A, I think, has been in since about 2021. That's the provision that is being amended effective 26 August. But so the existing position, just if we get into the technical definition, it's a person is a casual employee if they accept an offer for work from an employer knowing that there is no firm advance commitment to work or to continuing an indefinite work. So as I said, you then apply that test. So that's the test. Then in terms of how you apply it by reference to the terms of the contract. That is the current position as at today. Now,
shortly coming, the new definition of casual employment, and we were having a discussion about this before coming here today.
Yeah.
While it's a new definition and there are some changes to the existing definition of casual employment, the changes themselves aren't necessarily changing.
Yeah, I mean,
they're changing, but it's more in terms of how you actually apply it and what we need to consider.
Yeah. And that's it's almost weird because the slide's saying new definition of casual employment. The definition itself is changing a little bit, but not hugely. So it is a new definition, but the definitions don't look that different on paper. The key difference is it's how you apply that definition. How the definition's applied in order to get an outcome. So
the new definition under the new definition, employees will be a casual if the employment relationship is characterised by an absence of a firm advance commitment to continuing and indefinite work, and the employee would be entitled to a casual loading or a specific casual rate under an modern award, enterprise agreement, or their employment contract.
That's right, yep.
When applying this definition, consideration, it says on the slide, must be given to both the real substance, practical reality, and the true nature of the employment relationship and any terms of a written employment contract.
Yeah, so you can see there's the two elements.
Yeah.
There's one should be fairly straightforward. Does the person receive a casual loading or some kind of casual rate of pay under an instrument? Yes or no? That should be obvious. It's that very wordy, slightly kind of abstract definition of what does it mean to have an absence of a firm advance commitment to continuing an indefinite work.
And so when we think about what that means and what we might need to look at, this brings us to some of the key indicators of casual employment.
And under this, and so under the current law, lots of these factors could not be relied upon.
It was the terms.
That's right, because you
contract.
simply looked at what are the rights and obligations under the written document. Whereas now we get to look at these, or the courts are able to look at them, and these become relevant. Yeah.
So things like whether the employer can elect to offer or not offer work, whether the work is offered according to the needs of the employer, so on an as-needed basis, whether the employment relationship is described as being a casual employment relationship, whether the employee will have an irregular pattern of work, like we saw in Skeen and WorkPack. Mr. Skeen had a regular pattern of work. He knew when he was working. The employee is rostered, as I said, on an as-needed basis. The number of hours of when the employee will work will vary depending shift to shift. The days on which the employee will work will vary between weeks. The future availability of work will be uncertain or unlikely. And finally, whether the work performed by the person is different to the work being performed by part-time or full-time employees. But it's important to remember that no single consideration, so no single feature on that slide is determinative on its own.
Yeah, and look, there might also be a range of other factors that are not on the slide that are also relevant. I think the bottom middle one is probably a fairly critical one. If we think about absence of a firm advance commitment for work. And so if someone if it seems clear that there is going to be work available and it's likely that the person will be given access to that work, then it's potentially hard to argue that there's an absence of a firm advance commitment for work. So if you look at future availability of work will be uncertain or unlikely. That seems to be a different way of saying absence of a firm advance commitment of work. But clients ask all the time, what does that mean? It's almost impossible to kind of give a clear explanation. You'd rattle off all of these types of factors. But it's effectively that it's not the engaged and paid as such definition. It's the, let's look at the reality, the practical reality, the substance of the arrangement and say, does this fit the box of casual, yes or no?
Yeah.
And
when weighing those factors up, that's ultimately.
Absolutely. And some of those factors might point towards permanent employment.
That's right.
Other factors might point towards casual employment. And so, courts will apply and they will exercise or they'll apply an objective evaluative judgment. That's which is kind of very difficult because like minds can differ on a range of these things. So where does that leave us?
With 4 categories.
Well, yeah, and before we get to the 4 categories, I think what some people would say, and this segues nicely into transitional arrangements and things, I think what some people would say, and I think this is a fair comment, is the old Section 15A, which is the Rosato definition, had far greater certainty because the contract sets out the arrangement. You look at the contract, it's black and white, it's written, there's no ambiguity, and you can put someone in a bucket, a red bucket or a blue bucket. Post Rosato, or post 26 August, suddenly I think the test is less certain. I think that's a very fair thing to say.
Well, and it created this complexity that, a casual employee could at some point morph into a permanent employee at some unknown time.
Well, and that was one of them. That the full federal court scheme and work pact decision that was before the Rosado High Court decision, probably one of the most concerning parts of that decision was that the judge, I can't remember whether it was the single judge or the full court that made these observations, but they basically said, look, someone can commence legitimately as a valid casual, but then at some later point, by reference to their working pattern, they might later become a permanent. And that is hugely problematic for employers if that's the law. And we'll talk about why we don't have to be as concerned about that now. But that was massively problematic because it's like saying to a small business that has casual employees, every month or every Sunday night, you had to look at each casual's roster,
their working pattern
going back the last 3 months, and go, are they still a casual or have they morphed into something else? And you'd have disputes about when they morphed, because once they morph, that's when leave starts accruing. Just a real kind of nightmare. But thankfully, the way in which these reforms have been put into effect and the transitional arrangements have alleviated that concern. So we'll talk about that. But yes, you're right. So if we think about, and I think trying to apply all of these new legal definitions in a more practical and pragmatic way for businesses, I think there are effectively 4 categories of employees. So if we talk about the first one, we've got pre-existing employees who are casuals. And I take this with a grain of salt, but we're saying true casuals in the sense of not regular casuals. We're applying this kind of loose distinction between, a daily hire casual, if you like, very irregular, versus someone who might be a casual for and has been a casual for 4 years. So you have those ad hoc casuals who were employed with you prior to 26 August. If we think about them, come 26 August, they're not going to morph into something different.
No.
They're going to remain casuals, and effectively there's no dramas. No problem. So they're fine. Category 2. So you've then got pre-existing casuals, so those employed prior to 26 August, but who, let's use the loose phrase, are regular casuals. What happens come 26 August? The concern was that these regular casuals would suddenly just, effective 26 August, would be permanents. And look, I give some credit to the government in implementing these reforms. They've listened to the concerns of business groups and others, and they've very helpfully, I think, made it clear that no, come 26 August, that person is not suddenly going to become a permanent, because under the new test, they do have a firm commitment of ongoing work. So, however, so 26 August, they will remain casual, even though they're regular casuals. And so here's the irony. Come 26 August, they're a casual. They potentially don't meet the definition, the statutory test of a casual. So at law, they don't meet that test.
They might be working regular hours.
Correct. But what the transitional arrangements say is, no, so long as they were lawfully and validly engaged as a casual under the old test, prior to 26 August, then they are effectively deemed to meet the new definition, even though on paper they might not meet that new definition. So it's all a little bit clunky and technical, but in short, what that means is your existing regular casuals on the 25th of August, come the 26th, will still be casuals at law, irrespective of whether they actually meet that new definition. But because of their regularity, they may at some point, and we'll talk about this later, but they may at some point then be eligible for casual conversion.
Well, the new employee choice.
Well, yes. I think the law the Fair Work Act might use the phrase employee choice. They're using lots of new phrases that don't necessarily reflect
what's actually
what we're used to, and what most people will just say casual conversion, but we've got this employee choice type phrase. I'll draw some parallels between the same job, same pay reforms, you go to the Fair Work Act, there's not a single mention to
No.
same job, same pay. They use this clunky regulated labour hire arrangement
Yes.
order, and you just go, well, why didn't you just say
What
same
is-
job,
yeah.
same job, same pay order? But so category 2, they will stay casual, but they potentially will have access to employee choice casual conversion. Then we get to category 3. So category 3 and 4 are looking at future employees. So we're talking people who are employed on or after 26 August. So if you engage in category 3, you engage someone as a casual, let's say in September this year. Because we're engaging a true casual, they will meet that definition,
the new definition,
under section 15A. And so no issue, no drama, they're a casual. Category 4 is really the category that you need to be concerned with and need to get your house in order for. So this is employees engaged on or after 26 August who you might want to engage as, again, using this very loose phrase, regular casual. The concern there is that for those people from 26 August onwards, and we're talking about new employees, if on commencement they don't meet the new section 15A definition of casual, then I think you've breached the Fair Work Act, because you've effectively misrepresented to them what the terms of their employment is. You've misclassified them. You're suddenly not accruing leave and not giving them all the other. So that's really the risk area here. Future employees post 26 August who you might want to work regularly. How do we deal with that?
Well, and we've had a lot of questions come through in regards to, you've got casual employees who should be considered permanent workers, but they may not want to convert.
Yeah.
They might want to remain as a casual employee and have access to those rights. And it's a real question about what we do with those employees and how we manage that situation going forward.
Yeah, absolutely. And look, there's the complexity, I think, is around the transitional type arrangements in August, and then post-August, it's those conversion arrangements that can be complex, prescriptive, all that kind of stuff. But if we try and think, okay, conceptually, how do we deal with this scenario? Well, I think the answer is, if you're engaging someone post-26 August, you need to get the mode of engagement correct. So if they don't meet the test, if they don't meet the new definition of casual, then you can't engage them as a casual. You have to engage them as a permanent. Now, in that context, you are assessing whether they meet the definition on commencement. So the grey area might be that you could have someone who you wish to engage in September. You want to engage them as a casual because you think, well, workflows are uneven, we don't quite know how many hours we can give the person, et cetera, et cetera. So you may legitimately engage them as a casual. They might work irregularly. They might not have a firm advance commitment of ongoing work. You're not promising them future availability, et cetera. But at some later point, 3 or 4 months down the track, for example, by then you might be giving them 38 hours a week. And so you ask yourself then, is this a problem? The legal answer is, you just have to get the engagement right on commencement.
From the beginning,
So if you're engaging people who are going to be regular, who are not going to have an absence of a firm advance commitment to work,
that's going to be an issue.
Then that's an issue.
But
if you are engaging people who at least commence
as a casual,
legitimately, the fact that they might at some later point morph or change in such a way and so that's fine, because how the legislation is going to deal with that is, if they start working regularly at a certain threshold point, I think 6 months, they can then elect to convert to permanent. So I appreciate that's all probably very long-winded, but if you think about those 4 categories, category 4 is the problematic area that you need to get your heads around. Now, do we have some transitional things here?
Well, I think you've just covered this as well, the impact of the reforms. But as you went through, category 1, no real impact. Category 2, these employees will have access to casual conversion.
Correct.
Category 3, again, no real impact. And category 4, this is where the problem really lies.
Yeah, and it's only a problem if you get the mode of engagement wrong on commencement. If they are being engaged genuinely as casuals, but with the possibility that it might change into something else, then I think they're in the same category as category 2, which is you just need to get the definition right at the start, or get the mode of engagement right at the start, and then at some future point, they then will have access to that casual conversion. Sorry, we should have moved to that slide.
That's right.
I didn't realise we had it.
Morphing. Under possibly the most helpful aspect of the casual reforms is that the government has provided some certainty, which we touched on the uncertainty earlier. They've provided some certainty around converting to permanency. And under the new arrangements, it's not possible for a casual to simply morph into a permanent employee.
Yeah.
So it can't be the case that I'm a casual employee now, and then 5 minutes later, I become a permanent employee.
Or the concern was on 26 August, suddenly hundreds of thousands of casuals across the country wake up on the morning of the 26th and they're suddenly permanents with leave entitlements and all that sort of stuff. And this is what I said before, which is I think the devil's in the detail, but I think the transitional arrangements are actually quite sensible to try and, because whenever you're changing the law, it's easier to change the law when you're dealing with new employees. But when you've got existing employees, you need to try and change the law in a way that doesn't immediately disrupt all of these existing arrangements.
Yeah. And that means that once a casual is engaged correctly as a casual, they'll remain a casual employee until the occurrence of a specified event. So when we look at what a specified event might mean and the triggering of a specified event, a casual employee, as I mentioned, will remain a casual until 1, their employment status is changed to full-time or part-time employment in accordance with the employee choice provisions, and we'll come to that a little bit later on. Their employment status is changed to full-time or part-time employment in accordance with the terms of an industrial instrument, so that might be modern award, enterprise agreement. Their employment status is changed by an order of the Fair Work Commission under the Fair Work Act's new arbitration powers.
And that's an interesting one, so we'll talk about that.
And the employee is offered and accepts an alternative offer of employment that is not casual employment.
So the helpful thing about that is, as we said, you don't morph or you don't wake up on the 26th of August and suddenly be different. And so for employers, this provides some peace of mind, because really what the legislation is saying is the only way someone can change from a casual to something else is one of these 4 events. Outside of those 4 events, they won't change. So I think that's hopefully reassuring.
And now,
casual. I'm going to call this casual conversion because that's how it's developed. But the legislation talks about this employee choice. But most people will be hopefully reasonably familiar with the notion of casual conversion. I think it's been in modern awards. Again, the history lesson, the sequence of events, I think, was put in modern awards in about 2018, 2017, something like that.
Around that.
It stayed in modern awards until about 2021 when they put it into the National Employment Standards. So once it went into the NES, it's obviously got broader application because it would apply to non-award covered people. As a result of that, the Fair Work Commission then effectively stripped all the casual conversion clauses out of most, I think, if not all modern awards. So the modern awards now, at that point simply said, and I think today say, casual conversion rights are as per the NES. So it went from the awards to the NES, and so now it's going to stay in the NES. But the mechanisms around casual conversion are changing. So, and I think when the award conversion provisions went in, most of it was after a certain period of time, an employee could request to convert, and employers could decline on reasonable business grounds. I'm paraphrasing. Some of those modern awards actually imposed a positive obligation on employers to offer casual conversion. I don't think it was uniform across the entire award system. It was only some awards. And so by taking it out of the awards, putting it in the NES, we have a more uniform system. But effectively, after a period of time, and so it's 6 months for most businesses, 12
12
months for small business employers,
That's
so
right.
with fewer than 15 employees. So after 6 months of employment, if the person believes that they are no longer working as a casual, they
Yep.
no longer meet that statutory definition of casual, they can issue what the legislation refers to as a notification. For all intents and purposes, from what I can tell, it's effectively a request. The phrase notification puts it higher than a request because it sounds like I'm just notifying you that I'm converting as opposed to asking for your permission. But I think for all intents and purposes, they indicate that they want to convert.
Yep.
There's an obligation to consult
There is.
with the employee about that request or notification. There's time periods for a response. There's an obligation to respond in writing.
Within 21 days.
Within 21 days. So lots of kind of, I don't want to say box ticking exercises because I don't think they're box ticking exercises.
Quite prescriptive.
But prescriptive in the sense that if you fail to do one of these things, so you fail to consult, you fail to respond in writing, you might meet the 21-day time frame, but you didn't put in writing, or you might put in writing, but you missed the 21 days. Correct me if I'm wrong, but for each of these things, if you don't do it, you're in breach of the Fair Work Act.
That's right.
And so obviously penalties apply. So quite a prescriptive process.
When accepting.
So if you're accepting, there's some specific things that you need to communicate to the employee in writing. So if they're converting from casual, the question becomes, well, are they converting to full-time or part-time? Obviously, you need to work that out. You need to advise them what their hours are, effectively what their new terms of employment will be, the date on which that commences, et cetera, et cetera. And then the big one is if the employer is declining, you need to give reasons in writing why you're declining. And so we should probably then talk about what the test... well,
first, let's just touch on the transitional arrangements for casual.
And then we can come back to
what the grounds are.
When an employer can decline.
Yeah. So you've touched on earlier that there are some transitional arrangements in place for existing casuals. And under the new regime, this means that the existing obligation to offer casual conversion under the former regime will continue to apply for your existing casuals until 26 February 2025 for casuals who are employed prior to the commencement date, and that's for non-small business employers. For small business employers, this will continue to apply until 26 August 2025. So just a slightly longer period.
Yeah, and so it's a little bit kind of technical, those transitional arrangements, because even though the laws come in on 26 August, if someone then in September requests to convert, they might have been with you for 4 years, but the conversion rules will be different. And effectively, you're applying the old rules because they haven't met the 6-month period post 26 August.
Yeah.
So a little bit kind of technical, so just be a little bit conscious of that. All right, so... Responding. So we talked about the need to consult prior to deciding whether to accept or decline the notification. We talked about the detail that needs to be provided when you are accepting, and then we talked about needing to give reasons when you're declining.
I think what's important to touch on is if it's challenged.
And so if we talk about the basis upon which you can decline, the old world was reasonable business grounds. Do we have a slide?
Yeah, let's go to it. So the grounds for declining. Under the new regime, the grounds for an employer to not accept a notification can include that the employee still meets the definition of casual employment, that accepting the notification would affect compliance with a recruitment or a selection process, or that there are fair and reasonable operational grounds for declining. And when we look at that, that might mean whether there are substantial changes that would be required in the way in which your enterprise is organised, whether there would be significant impacts on the employer's enterprise, or whether the changes to the terms and conditions would be reasonably necessary to ensure compliance. I think...
so substantial changes are needed to be made in order to comply with the award. So if we just have a look at that. So the old world was we can decline your request on reasonable business grounds, and you can articulate what they are. The test is different here. So we're talking about fair and reasonable operational grounds for declining. And the legislation doesn't define that necessarily,
No.
but it requires the Commission to have regard to those three things.
Factors.
And if you just quickly look at that, we're talking about substantial changes, significant impacts, substantial changes. So they're trying to set the bar reasonably high.
I think it's going to be harder to decline than probably what it's.
Yeah, I think that's right. So the short takeaway is it will become harder to decline a conversion request. And where you are declining or wanting to decline, you effectively have to have some pretty good reasons or compelling reasons as to why you're declining.
But that doesn't mean that we will see an increase in employees choosing to become permanent employees. I mean, many casual employees still wish to remain as they are. Yeah.
I think that's right. And we might go back to the previous slide and just touch on the arbitration dispute powers. But you're right. I mean, if you try and summarise all of this, what we're saying is the definition is changing. So post 26 August, for new employees, you need to get that mode of engagement right. If you don't, there's a bunch of consequences. Assume you then get it right, or the people are pre-existing employees, so that's fine. The next issue really is casual conversion. And as you say, Claudia, the anecdotal evidence at least seems to be that there's a fairly low take-up of casual conversion. So whilst the Fair Work Commission, the unions and Parliament have given all of these casual conversion rights, it seems that most employees don't really want to convert. But they're there if you want to. So, and then, so we've talked about who can make the request or the notification, how you need to deal with that.
If you might decline, what the basis is for that.
That's right, the test, what the basis or the test is to decline. And then this is an important point, I think. If you decline and the employee is not happy that you've declined the request, they can effectively take that to the Fair Work Commission as a dispute. The Fair Work Commission has power.
And I might just say, Carl, they can only take it to the Fair Work Commission once it's trying to be resolved at that workplace level first.
So they can't jump straight to the Fair Work Commission. They need to try and have a discussion with you and say, well, you've declined my request. I'm not happy about that. I don't think that's fair or legal. Can I talk to you about that? If the employee can't persuade you to change and they're still aggrieved, they can go to the Fair Work Commission.
Yes.
Now, there's a flavour or a trend in all of these reforms to give the Fair Work Commission greater powers to deal with those disputes. 10 years ago, it was fairly rare for the Fair Work Commission to have the ability to arbitrate, which is effectively hold a hearing, make a decision and impose an outcome by way of an order on you. Most of the dispute procedures or powers given to them were to conciliate, mediate, express an opinion, give a recommendation, that's right, but they couldn't impose an outcome on you. Here, under the new world, they will be able to. So if you're declining, if the employee is aggrieved, you just need to be conscious that you might find yourself in the Fair Work Commission, and if the Fair Work Commission disagrees with you and says, no, I don't think you have fair and reasonable, or fair and whatever it was, fair and reasonable operational reasons to decline, then the Commission has the power to say, no, you should have converted them. Here's an order that says effective X date, the person will be permanent. So just bear that in mind because that is a significant change compared to what we've had in the past.
We've covered that. So now if we move on to the casual employment information statement, we've had lots of questions about this. And the timing and when the statement needs to be provided. So I think the table is quite helpful on the slide. For both small business employers and non-small business employers, you will be required to provide the casual employment information statement on commencement. You'll then, for non-small business employers, you'll need to provide it as soon as possible after 6 months of employment. For both categories, you'll be required to provide the statement as soon as possible after 12 months of employment. And then finally, for non-small business employers, there's an obligation to provide it every subsequent 12 months of employment.
I mean, I have a particular view about this. I don't know whether I'm an outlier, but I think I've got no issue with the Fair Work information statement. You give that on commencement of employment. Most employers will staple it to the back of an employment contract, or they'll have a clause in the contract that has a link to it. It's on the Fair Work Ombudsman's website. It's pretty uncontroversial. I actually don't have a problem with a casual employment information statement, particularly if it was implemented in the same way, which is give it to the employee on commencement. I think this is an administrative nightmare.
Burden.
I think it's a regulatory burden on employers. I don't think it makes much difference in practice. I think this looks to me to be an idea that someone who has never run a business thought was a good idea. And it's about giving people rights. In circumstances where everyone has the internet in their pocket with their iPhones or their mobile phones, you've got the Fair Work Ombudsman issuing all this guidance material. I just think this is unnecessary. But
we need to bear in mind that it's there.
Not only is it there, it's there. Might not be going away.
No.
It's there. If you get it wrong, you're in breach of the Fair Work Act.
That's right.
And if we think about the penalties, the way the penalties have just ramped up massively in the last few years, penalties for a breach of the Fair Work Act now, effective 1 July. If you're not a small business, the maximum penalty for a contravention is $495,000. So arguably, if you forget to give one casual employee this document at any point where it's required, it exposes the business to $500,000 in penalties. So it's significant penalties. If you think about how this works as well, we're not talking about giving it to people on commencement and then every 1 January.
No.
Or every 1 January and 1 July. It's on the anniversary of their commencement date. So theoretically, if you had 365 casual employees,
you need to know.
You're probably giving it out on a daily basis.
Yeah.
And I joked, and it's a very bad joke, and I've repeated this very bad joke multiple times, and I'll do it again. I said to some employers, rip up the carpet in your office and
lay the floor.
Lay your floor with the casual employment information statement. Like, you can't overgive it, but you can definitely undergive it.
Yeah.
Now, don't do that. I should come up with some trademark or IP to try and make money out of that. But I just think it's ridiculous. So the short point is, if you've got lots of casuals, you're going to have to come up with a way to systemise this, to automate it, so that from your payroll system or whatever, every time the relevant date gets hit, it goes out via email or it goes out in some way. Because if you don't get this right, just imagine the potential contraventions that you're exposed to. It's a bit of a disaster.
And I think it's important to keep a record of how and when you provide the statement, and potentially, as we've said, audit your current casual employees to understand when their anniversary dates fall, so that you know when you need to be handing these out.
Yep.
Protections for casual employees. Under the new regime, an employer is prohibited from dismissing or threatening to dismiss and re-engage as a casual employee, making false statements to persuade a person to enter into a casual contract, and misrepresenting employment as being casual employment.
And I think that third one is a live issue for business because, as we've talked about, it's not always black and white as to whether someone is a casual at law or a permanent. So if you're recruiting, you're hiring someone and you're saying, I'm going to hire you, the job is a casual job. If you're wrong about that, you've just potentially misrepresented the nature of the employment, and therefore, I think it's a contravention because you've engaged in a misrepresentation. So you need to, every time you're hiring someone, you need to know with a high degree of confidence, are they a casual, are they a permanent?
Yeah. And have that correct and get that right to begin with. Yeah.
And if you get it wrong, then obviously it creates financial issues, because although you might be paying a casual loading, you're not accruing leave and other things.
That's right. And so the penalties for these offences can be up to $99,000 for individuals and $495,000 for companies. And this went up this week as of 1 July. Yeah. So for employers who misclassify employees, they should be aware that you may be liable for back pay from the start of the employee's employment for unpaid permanent employee entitlements. As Carl mentioned, that includes annual leave, personal leave, etc. But it's likely only going to arise when the employer incorrectly misclassifies an employee from the start, from the commencement.
And when we say from the start or from the commencement, it's really from the start or commencement on or after 26 August.
That's right.
Yeah. So, and these protections I think they sit in the general protections scheme of the Fair Work Act. So there's additional rights, etc.
Practical tips.
So try and wrap all that up. And we'll probably talk loosely to this slide, but I think I would try and conceptualize it in two categories. There is the definitional, foundational, are they a casual, are they a permanent? You need to get that right. You need to understand those transitional arrangements for existing versus new employees. That's very important. Then the second category really is casual conversion. Do we understand how conversion works? How do we deal with conversion? If you're a large business, I think one of the traps is going to be an employee asks the supervisor to convert.
Yeah.
And the supervisor, who's completely oblivious to all this, goes,
doesn't know.
No, you're a casual.
Yeah.
They don't have a clue about the 21 days, the written thing. So if you're a larger business, it's about how do we roll out some process, some policy to make sure that if a request is made, it goes to the person who knows how to deal with it, who deals with it properly. So I think they're the couple of categories. I've given my view about the casual employment statement. That's a real kind of administrative headache, but you need to do it because it's required.
It's a requirement.
For newbies, you need to get that engagement right, and that is not simply by reference to the contract, but it's also by reference to the reality of the arrangement.
Contracts.
So although contract is no longer king in the sense that it's not all about the contract, it is still a relevant factor. So it's still important. And so when the courts deal with these disputes, they're going to look at both the terms of the contract and the practical reality. So it's still relevant, and you want it to be as solid as you can. So it's probably timely to be looking at template casual contracts to make sure that they're as robust as they can be. Then you've got onboarding processes, so making sure, as I said, you get that engagement right. So that is possibly an education or training piece for hiring managers. You know, some businesses back in the days had a policy of just we engage everyone as casual for the first 6 months. And then after, if we like them, they get rolled into permanent. You can't do that anymore. So hiring managers need to be aware of that. For existing casuals, it's probably timely to be looking at how you utilise casuals. Have we got the mix right? Even though there might not be an obligation to offer conversion, it might in fact be cheaper to offer conversion. If you've got a casual who's working 38 hours a week, every week,
regular,
it is probably more expensive to be engaging them and paying them as a casual than if you offered them permanency. And they have the same unfair dismissal rights, most likely. So the question is, well, you're paying more, what are you getting in return? And I've talked already about that casual change process.
So we also have a casual employment handbook that can be accessed and downloaded during today's webcast. I think there might be an icon on the, is that right, Kyle? On the side of your
So you should
screen.
be able to see some click boxes where you can click through to the handouts and you get access to the casual employment handbook. So that should be a very good guide. If you want to get that, please grab it now. And otherwise, you know, I think ABLA is running regular training sessions. We do a lot of training in this space. You know, we issue alerts through our website. If you want to subscribe to get access to articles and different things, there's an ability to subscribe by clicking through our website. There's a phone number there. I think that we're probably slightly over time. So hopefully we haven't kept you away from other stuff, but hopefully we've moved you out of the stage of overwhelm through to understanding what you need to be doing, and you've got some kind of practical tips to try and move forward.
Yeah.
I think we'll wrap it up.
I think that's it.
Thanks very much for joining.